Maybe must bracket me. Okay, hold on, bracket you. Okay.
Bro, can you just pass me that big bag there? Thank you, sir. Okay. Are we good to go? Good morning, colleagues, members of the Fourth Estate. Today is the 19th of August, 2015. My name is... My name is Zola Majavu. I am the lawyer of record of Advocate Nomgcobo Jiba, whom I will refer to as my client for purposes of today's business. On my right, Tu Tomakuta, an associate at my firm. As you can see, it's Women's Month, and I thought she must also be empowered by participating in this press briefing with me, and she has been with me throughout the commencement of this matter with Advocate Jiba. Colleagues, thank you for having made it, and I'm very pleased that we spot on time. Let me just indicate how we are going to transact the order of business so that we all know where we stand. Firstly, colleagues, we are going to start off by affording Advocate Jiba an opportunity to speak to you guys. I don't know what she is going to say. What I do know was that when this matter commenced, I advised her not to say anything to the media, regardless of the barrage of inaccuracies that were peddled against her, and advised her, which advice she accepted, to resist the temptation of wanting to speak publicly to defend herself, because she still is a senior member of an institution that all of us must respect and protect. And for those reasons, she elected, on my advice, not to say anything to the media. She does accept that the position she occupies is one that is indeed in the public domain, and therefore the dictates of public interest would demand that at some point she must say something. That point has now arrived because we took the view that while these court processes are pending, it would be inappropriate for her or myself to be seen to be making those utterances. So she's basically here to say, as a public servant, I too want to be heard on whatever issues that she would like to share with you. Once that has happened, I would then take you through a very brief narrative of what transpired from day one when this criminal matter commenced, right up to today. And I will spare no effort. I will share with you as much information as I possibly can. Where I am able to back it up with documentary evidence, I shall do so, purely for the sake of transparency, so that when you do report, you do so on the basis of information at your disposal. I must say that I've listened to some of your commentaries, and I became more determined to proceed with this conference because I realized that a lot of things were either misunderstood or were simply incorrectly reported. And I thought this opportunity is available to all of us to clarify one another. It's not meant to be a spin. You'll get information raw as it is, and then you will draw your own conclusions. At the end of my detailing of that narrative, I would then be available to take one-on-ones with every single one of you, either collectively or individually. But obviously, Advocate Jiba would not be in a position to engage on those one-on-ones. Whatever you may want to ask, let's use this forum to ask, and between me and her, we'll determine whether it's appropriate for her to take certain questions. You must understand that in terms of her own protocols, I mean, the boss has spoken yesterday, and it would therefore not be correct to be seen to be revisiting some of the issues that the NPA had, spoke about. But we are not necessarily going to shy away from providing the necessary clarity. But I think you must just bear that in mind. So to the extent that she might not be able to give you the juicy stuff, it is not because she's not equal to the task. It may well be out of observance of protocol or taking the view that her lawyer is better placed to deal with those issues. And I think with that understanding, I'm more than happy to then get this show on the road, and as and when we develop, we can then engage more meaningfully. Are we okay with that approach, colleagues? Very well. Then I'm mindful of the time also. I'm going to try to keep us short so that those of you who have to file, do so timeously, and you don't have to rush for your next bullies. So we are also at the same time not going to curtail your questions unnecessarily. We are here, we've got the time, but at the same time we must remember that even good things at some point must end. May I then take the pleasure of introducing to you the Deputy Director of National Prosecutions, Advocate Nomgcobo Jiba. And all other issues about what her current position is will be dealt with during the course of our discussion. Thank you.
Good morning, members of the media, and thank you, Zola, for that introduction. May I also take this opportunity to wish all women in South Africa and around the globe a happy Women's Month. They always say, Watindi Mbokoto, Watinda Bafaz. I'm from the Eastern Cape. That's how we say it. Colleagues, let me start by saying that indeed I've been very hurt. I said to you this morning, I am a human being, just like any of you sitting here. I come from a family myself. I've got a family. I've got children that are very young. They go to school. One of them is 17, one of them is 14, and my youngest princess is 2 years old. My parents are very old, 81 years of age. I'm the last born at home. So everything that has happened and that continues to happen, it hurts them, and it hurts me deeply at the end of the day. I have been called names. I don't know where these names come from. I don't look like a diva, but I've been given names. I've been called a diva. Some have said, I remember reading something that have said, Nomgcobo Jiba's 9 lives. And I have only 1 life. I don't know what is meant by 9 lives. But I guess the authors of those names would know what that means. I have felt very insulted. and I won't say by the members of the media. I assume you were getting those from your sources that you're allowed to protect. As my attorney had said, I did indeed take advice from him not to respond to anything which was said in the media. I was tempted a lot to respond, but I couldn't because I had to take advice. If I have requested him to be my legal representative, then I have to naturally take his advice. As a prosecutor, I started the job of prosecution in 1988 in a small district called Pedi in the Eastern Cape. That's where I started. I have grown through the ranks of prosecution. I was trained at the Justice College. Then we used to call it Justice College training. So I have been prosecuted. I was not just picked up from the street in 2010 and promoted to the position of a Deputy National Director of Public Prosecution. It's something that I have been doing for all my life. So it goes without saying that I have been making prosecutorial decisions since 1988. I did not start making prosecutorial decisions in 2012. I've been making them since 1988. I was very young there, and I look younger than I look now. So I remain committed to the National Prosecuting Authority. And I remain committed to the Constitution of this country, which requires us as prosecutors to prosecute without fear, favor, or prejudice. We should never make our decisions based on some pressure or some popular ideas from members of the media or from whoever. We should make our decisions based on the evidence which is presented before us. I don't want to dwell on the merits of the case and the demerits of the case. Suffice it to say, all I want to tell you today is that whenever I make decisions, I make them on the basis of the evidence which is available before me. Naturally, in our legal practice, that is why there's an attorney and that's why there's a prosecutor. Those two, when they present a case, they present it so differently. The other one sees it the other way, and the other one sees it in the other way. Equally, you know that we have a hierarchy in our court system. We have lower courts, we have high courts, we have the Supreme Court of Appeal. Judges in the Supreme Court of Appeal sometimes differ with the judgments of the judges from the lower courts. And I'm sure you do know that. Even in the Constitutional Court, that's what happens. In certain circumstances, you'll find that judges sitting together in a particular case, a judgment will be, there's a minority judgment, and then there's a majority judgment, because the judges have differed amongst themselves. And when a judge differs with you, it doesn't mean you are committing a crime. It simply means that the judge differs with you on a particular point of law. It doesn't mean that the judge in the lower court is suddenly committing a criminal offense. Nor does it mean that an attorney or an advocate who is criticized by a judge for one reason or another, he's suddenly committing a criminal offense. It can't be. But as I said, I'm not here to dwell on the merits of that. I'm just making a point that you need to begin to understand that otherwise, that is why we have this system. We have a system whereby decisions are subjected to scrutiny. Otherwise, my prosecutors, I'm afraid, would all be charged for having committed criminal offenses once judges disagree with them. As I said to you, I remain committed to that institution. At some point in time, I was tempted to resign. But I said to myself, I'm here to serve the people of this country, and I'm going to remain in the National Prosecuting Authority. That is all I would like to say for now. Thank you very much.
Before we swap places, can I just establish if there are any questions that you wish to direct at her based on what she has said, so that by the time we swap, you have had a fair share. I've noted 1, 2, 3 hands, and that will be it. Or 4, 5, in that order. You may start, ma'am.
Advocate Jiba, I'm Holy from Media 24. Advocate, one of the nefarious things said by you, or to you, about you, was that you are biased and that you are making decisions, prosecutorial decisions, so as to help and allies yourself with certain people, especially political cases. Advocate, why do people say that, and what do you think about those comments?
Let's take the second question.
Good morning, Advocate. Barry Bateman, Eyewitness News. Advocate, you refer to a lot of things that people have said about you in the public domain which has hurt you. Let's confine perhaps the criticism of you which has been said in a court, which is perhaps where it is most valuable, because as you made clear, you are a prosecutor. We go to the Gorvin matter, which is what is partly related to why we're here today, the findings made against you there which resulted in the perjury charges. Let's go to the Supreme Court of Appeal in the DA matter and the spy tapes, where it was found that your conduct in that particular matter was unbecoming or not fit for somebody in the office of the National Director of Public Prosecution. So, are you fit for office? Are you of the person that fits the qualities of this new position that you've now taken up as head of prosecutions in the NPA? And to follow on my colleague Poli's question, the President Jacob Zuma expunged your husband's criminal record. You stopped the prosecution of Richard Mdluli, and you also did not hand over the spy tapes. Are you acting for President Jacob Zuma in the NPA? And if you're not, why did you make those decisions?
Okay, let's stick those two so that you can respond. And I'm going to appeal to colleagues. Let's try to keep the questions short so that everyone has a fair chance. And questions must be questions. We mustn't preface them with statements, because now you're going to end up with an open-ended answer. I'm not being defensive. My client is more than capable to respond to the nub of what she understands the questions to be.
I'll start with your question being biased and helping out people. I've never helped anybody. You see, when you are acting, because I believe that your question relates to the period when I was acting, when you are acting as a national director, you are surrounded by a number of people who are then responsible for making various recommendations to you after, of course, having conducted investigations on particular issues. So the short and simple answer, I'm not biased at all. I cannot be biased. If I have been a prosecutor from 1988, and I'm still one now, I think my biased attitude could have even appeared in my younger days as a prosecutor. I hope that answers your question. Barry Bateman, I'm glad I've met you eventually. You've said a lot about me in the media. And I believe you're one of those really have painted me in the negative light in the media. I'm not going to comment on Judge Gavin's judgment. I won't do that. I believe that is in the hands of the National Director of Public Prosecutions as we speak. The issues about the comments made by judges of the Supreme Court of Appeal, you would do yourself a favor. Go to our papers, because otherwise I'll take long if I have to respond to you now. The GCB has filed an application and it has based its reasons for filing such applications from those judgments. Do yourself a favor, go to our papers and read them. You will see exactly what we are saying in those papers. What was your other question, Barry Bateman?
Yes, it was related to Zuma expunging her husband's criminal record. You stopped the prosecution of Richmond looting, as well as not handing over the Zuma spy tapes. And the straight-up question is, and this is a popular perception of you, that you are acting for President Jacob Zuma in the NPA. Is that true?
I was going to say, when we refer to the president, let's at least give him the title President Zuma. In my culture, it's not correct to refer to elderly people with their first names or their surnames.
I think many people have been accused of working for President Zuma. I've heard recently that the Minister of Police also has been accused of working for President Zuma. I cannot work for President Zuma. I can't work for President Zuma because I'm a prosecutor. As I said to you, my responsibility is to prosecute without fear, favor, or prejudice. Number two, if my husband's record were expunged, it's none of my business. I have no criminal record that needed expungement. If those that were considering the application deemed it fit to expunge it, really it has nothing to do with me. I am who I am, and he is who he is. We exist independent, and I'm sure you also exist independent of your wife if you're actually married.
Okay.
The spy tapes.
Oh, sorry.
I've never refused to hand over any spy tapes. The spy tapes have always been in the custody of state security. All that they needed to do was to get collected from the state security. I don't know where it comes from that I'm keeping the spy. How would I keep this? Where would I keep the spy tapes?
Thank you.
Just your thoughts on calls to change the legal just what are your thoughts on that? And would you consider that?
Would I consider what?
The call that's been made.
Let's see the lady at the back and then.
Amanda Watson from the Citizen. Just a follow-up question to Gillian. If you're removed from from the Bar Council, how do you intend to proceed in the NPA? Are you going to fight this?
Last question.
Good morning, Advocate Nicholas Barr from eNCA. You said on the steps of the Specialized Commercial Crimes Court that you feel vindicated. How do you feel vindicated when these allegations were not fully tested in the court of law, but just the charges were dropped? And moreover, are you confident that you can say that you feel vindicated when you still have these matters hanging over your head? These accusations made against you, rulings by the Supreme Court of Appeal, that you're not a fit and proper person to be an advocate, and that you have not conducted yourself in a manner that is commensurate with an advocate's action.
Okay, that was the full round. If it's a short follow-up, I'll allow it. Otherwise, we're not going to get through.
And then the last thing that's a follow-up on that, there are talks of private prosecution. Will you fight it, and what do you think about it? And then will you try and appeal the Morgan judgment?
All right, that is it. I will allow my client to respond. Obviously, to be fair, you have raised a number of legal issues that I will have to pick the cudgels on and respond more definitively, because some of the questions are issues that we're currently grappling with. And now that you've put your foot in it, allow me to reciprocate in kind. But obviously, she will answer as best as she's. And those are fair questions, by the way. I really appreciate them, and I was hoping that you wouldn't go there for the sake of other people who are not here. But now that you put your foot in it, And for the sake of transparency, to share with the world what is happening on those issues, I am going to respond.
Okay. I can't quite follow your question on my thoughts on the GCB, but I'll try and answer it. I don't want to criticize the GCB for having made the application. It is certainly within its right to do so, but I find it strange. Many prosecutors have been criticized many times. I don't have a list now. I can give you a list of those prosecutors who have been criticized in courts of law. Many advocates have been criticized by judges, and the GCB has never brought the application to have them strike off the roll. And even judges themselves have been criticized by other judges. Now, I wouldn't know whether the GCB has got powers now to make application for the judges also to be reviewed. All I'm saying is that I find it strange, because these criticisms, it's not the first time for anybody else who is a prosecutor or a legal practitioner to be criticized by judges. Judges do that all the time. It's their job to do so. Now, you're asking me, why do I feel vindicated? Because the case has not proceeded. I was never afraid of the case going through trial. Remember, you are talking to a prosecutor. I've done a number of cases in my entire life. So I was never afraid at all to go through the trial. But remember, you don't prosecute for the sake of prosecuting. You prosecute because there are prospects of a successful prosecution. And there are consequences if you prosecute for other reasons. So that is why I'm saying to you, I do feel vindicated that the NPA has come to its correct senses. There isn't a judge in any of these judgments that had said, I am not fit and proper. So that statement is entirely incorrect. Go and read the judgments and quote what is in the judgments. There's none that have said so. But as I said to you earlier on, read our papers that we have filed. You will find that the questions that you are asking me today, we have responded to them thoroughly in those papers. Well, about private prosecution, I'll cross that bridge when I get there. For now, I really can't, I can't comment on it. I can't say anything about it. Thank you very much.
Okay. Just one, the Goldman case? Will you appeal? The judgment of Judge Goldman, will you appeal? Will there be a draft?
As you know, I'm not the head of the NPA.
No, that's why I
You really have to direct that question to the head of the NPA, who is the NDPP.
Because you're one of these deputies. Will you advise him to?
We have given that advice even before. The prosecution team had given that advice even before. So it won't be the first time. I suppose your next question would be asking me there what happened then when we gave that advice.
Let's pick up on that very last question, because you see, I'm not governed by those protocols. I will tell you chapter and verse. Firstly, that Groven decision was indeed appealed against. Now, this is what happens. In terms of our law, if you are aggrieved by a decision, you do not necessarily have an automatic right of appeal. You must first bring an application for permission to appeal. You bring that application before the same judge against whose decision you intend to appeal. I can tell you now, without fear of contradiction, that that application for leave to appeal was prepared and filed. I know so because it forms part of our answer in the GCB matter. And That decision was later rescinded to say, do not challenge the Govan decision by the predecessor of, yes, you've mentioned the name, I'm glad you did, which my client respected because it was his call as the head then. So I think people must know that that decision was not left unchallenged by the NPA at the time. However, a decision was taken not to proceed. And you know, in law, if a decision is not challenged, it stands. But if an appeal is noted against that decision, that very decision then stays suspended pending a higher court determining the matter. And logic would dictate to you, had that been the case, we would not be talking about these supposed quotes that you are referring to as criticism from judges. Whether or not the appeal would be resuscitated, we do not know. It is a matter for the current National Director of Public Prosecutions. So we deal with that issue. We don't skirt it. We deal with it quite extensively in our court papers. Secondly, there are certain aspects of those very judgments that everybody is hoisting on their petards to say you've been criticized by the judges. I can also tell you that in some of those judgments, the judges actually got it wrong. There were certain comments that were supposedly ascribed to my client when in actual fact they meant to say the National Commissioner of Police, a pure factual inaccuracy. But this is not the time and place to criticize judges or to raise those issues. The correct place to raise those issues is in our court papers, in the GCB application, and they are a matter of public record. You can go read for yourself in case I'm lying to you. Okay, so I just wanted to clarify that particular issue. That is what it is. That particular application is still pending before the courts. It has not yet been finalized. And I can assure you, once it is finalized, we'll come back here in a forum like this and say, yes, the GCB was successful, she is now removed, this is what we are doing, or they were not successful. But whichever way it goes, it is always decent to await the court to make a pronouncement before you start gainsaying each other publicly. What I'm telling you is what it is. In terms of where that matter is, there is an application to which she has replied. The GCB has an opportunity to reply to her answer if it so chooses. They are, by the way, out of time. They have not yet replied. However, if they do reply, we will then reach a stage that is called the close of pleadings, meaning that we would now be ready to approach a court to ask for the matter to be enrolled for hearing. But at this stage, we have filed her answering affidavit in response to the founding affidavit. The GCB has a further opportunity to file a reply if they so choose. At this stage, as at now, I am yet to receive the GCB's reply and affidavit, and in fairness to them, we need to await their reply. It would be improper to start talking about those in the public domain when we have not finished the filing of our papers. But whatever is, I've noted your handman, whatever is in the court file is publicly available. Maybe at the end of this hearing, I will assist you with the case number so that you can then go and uplift them yourselves. The very judgments that you are referring to are also the annexures to that application. And you will see, at no point did the judge say, my client is not a fit and proper. It is not a call for them to make. The closest that judges would say would be your conduct requires an investigation by your professional body, which would be either the relevant bar council or the GCB. There is no way that the judges would have made that type of call in relation to her. But you don't have to believe me, I'm simply stating the processes. While we're at it, let me give an example that may be closer to you. Her predecessor, Advocate Menzi Simelane, you would remember he appeared before the General Commission of Inquiry. And in that commission, I'm jogging your memory to show you that what is happening to my client is quite interesting. In there, the commission criticized him for his particular conduct. Do you all remember that? What then happened was, as a result of those adverse criticisms, The matter was then referred to his professional body, which is what? The Bar Council. As we speak, the Bar Council did not bring an application for him to be struck off the roll. Yes. The point I'm making, if you had allowed me to finish my point, the point is exactly that. He is subjected to a disciplinary inquiry, which is the correct thing to do. Because at the end of that inquiry, it may well be that the inquiry would find that he is indeed fit or unfit. The determination of his fitness or unfitness does not end there. Based on that determination, the Bar Council or the GCB may well decide, now that there is a finding of an internal tribunal, then approach the court for his name to be struck off the roll. Backtrack, what is happening here to Jiba? The courts criticize the one in KZN, the other one in the SCA. Based on the criticism that may well be subjected to an appeal, what happens? Not the Bar Council, the GCB brings an application to have her struck off the roll, without affording her the same courtesy and right that is being afforded to Advocate Menzi Simelane. It's just an example that I'm giving you. I do not want this press conference to be about the GCB application, because that is not what we are here for. But I said, seeing that you've put your foot in it, I will respond to it to try and make that point. And I'm glad you are sitting in that application, and you would know that in that application, Mr. Simelane, at the very least, is afforded the right to confront his accusers. He is afforded the right to an audience. Has that happened in respect of Advocate Jiba? You will answer that for yourself. What has happened is instead a straight application to the High Court that says, strike her off the roll. Lady, you asked the question. Of course, if she struck off the roll, she would automatically be ineligible to continue in her current position. It is a short-circuit way of removing her from her current position, because in terms of the law, she can only be removed by the president and following a particular parliamentary process. But once again, those are the issues that we are fighting in that relevant application, which we will ventilate in the High Court in due course. But what I'm telling you now, I'm not making it up as I'm going along. It is in the court file, in her affidavit, that deals with all of those substantive issues. You see, the point is not as simple as, do you consider yourself fit or unfit? Would you step down? She does not have to consider herself fit or unfit. If she wants to resign, she can resign tomorrow. But it cannot be she has to resign because judges have criticized her. That is not how our law works. And I've given an example where exactly a commission had harsh words to say against her predecessor. But even then, because they belong to the same bar, they belong to the same role. What happened there, there was no direct application to have him struck off the roll. Somebody then accepted that he is entitled to the right to be heard. That is why you have that internal disciplinary process. And actually, to tell you, one of the things that we say in our papers is, if she has violated the rules that govern her profession as an advocate, the rules of that profession also dictate an internal disciplinary process that must be undertaken to establish the facts, which is exactly why they have subjected Advocate Simelane to the same process. Now, the question is, why not subjected to the same process? It is not for you to answer. It's not for me to hazard a guess, but I'm simply saying factually, you can go and research all the more you want. That is what has happened. There is no disciplinary process that she has been subjected to by her professional body. One, there is no disciplinary process that she has been subjected to by her employer, which also remains an opportunity. In the next coming weeks, and I challenge you, we are going to call another press conference where we'll disclose to you who is actually behind that GCB application. It will be very interesting for you to know.
Why can't you tell us now?
Because it is not appropriate and I'm not stupid. Yes, it doesn't have to make sense for you because you're not my client. I am saying I am in the process of filing papers that I have to exchange with my colleagues. Why should I allow you the privilege of knowing before my colleagues? I am governed by a protocol. we are exchanging court documents. It does not make sense now because you don't know what it is. I am saying to you, we are yet to receive a response from the GCB. We have not responded that. You are not saying it's not making sense that they have not responded. I am simply saying the issues that I am referring to, I would not have made mention of had you not put your foot in it. I am saying to you, the GCB has brought an application to have my client struck off the roll, which she respects because they, as a professional body, are entitled to do so. But the fact that someone has brought an application to court does not necessarily mean that they are correct, does not necessarily mean that the court will give them what they want. She is entitled to respond to that application, which she has done on record, and those documents are filed in the court. The GCB intern is also entitled to respond to her response, which they have not done.
You said it ran out of time.
Come again?
You said they ran out of time.
Yes, but colleagues give each other indulgences all the time. I'm not going to take the point that they're late because tomorrow it might be me that might be late and my colleagues will grant me an indulgence. What I can tell you is that once I have exchanged further documents with them and they are filed in the court file, they are a matter of public record. Then I can talk about them. At the moment, I cannot talk about that because we have not filed that affidavit. It would not be polite. It would not be collegial. It will be downright stupid of me to do so. I do not want to take my thunder away. So if it doesn't make sense for you, I respect your point of view. I wanted to clarify the legal issues pertaining to that application because you guys started asking questions about them. Other than that, I want to make it very clear on record, I was not going to even go there. But I am glad that you have afforded me an opportunity to give you a teaser because it is going to be very interesting what has actually happened in that application. And trust me, I'm not a coward. I will put it in the public domain at the appropriate stage. For now, I'm happy to be referred to as not making sense. It's not affecting my balance sheet. I'm happy with that.
Just as a bit of a follow-on, will these problems that your client is experiencing perhaps not necessarily fall away, but become a little bit easier now that there's a new head of the prosecuting authority?
I'm unaware that she's got problems. I can tell you that whatever legal issues that may be, she will subject herself to the rule of law and will take whatever comes our way. And actually, before I start taking on the narrative of how we ended up here, because it's very important, because the media has a tendency of missing these things out because they're not juicy enough. Let me tell you, up until 11:45 yesterday, I was still preparing for the trial. And the trial was supposed to start today, tomorrow, and a few days in September. Having been provided with the contents of the docket by the prosecutor. You can quote me on this. That docket is 1,475 pages, and I read every single one of them. It translates to 36 Archlever files. We were given that information about 2 months ago. We were ready to go on trial, as my client said. We have never been scared of going on trial. She was not done a favor by the latest stance adopted by the state. As a matter of fact, even her predecessor was warned that there are problems with this case. They elected to proceed. We respected that. We would not have gone to court today if we were not trial ready, ma'am. We were trial ready because the state gave us the docket on which it is going to rely to prove its case and allegations against my client. It is the state that decided yesterday to publicize their decision. For all I care, I would have been happier had the trial proceeded because I was going to make good billable fees. But let me tell you what everybody has missed fundamentally. And ma'am, at this stage, I am going to tell you something, and I'm also going to give you a document in case I'm a liar. They say lawyers are liars. And Nicholas, the charges have not just been dropped or withdrawn, because that presupposes that there might have been insufficient evidence, they can still be reinstated. And your question or your observation is fair, addressed to her, and I can understand where you are coming from. Let me read what the regional head of the SSCU in Pretoria had to say. And then you'll conclude for yourself. I will say no more on that issue. Then you will understand the point I'm making. Firstly, in the ordinary course of prosecution, the National Director of Public Prosecution doesn't make decisions necessarily to prosecute. Those decisions are taken by the deputy directors. It's not new to her, it's not new to Ngasana, it's not new to Advocate Sean Abrahams. The deputy directors take those decisions, having considered the docket that is placed before them. This particular decision was similarly not taken by Advocate Sean Abrahams, because it is not his to take. And there is nothing wrong with that. It is consonant with their prosecutorial protocols and policies. But let me read to you a letter that was sent to me yesterday, informing me of the decision taken by the NPA. I will also share with you the communication that I had with the person who was supposed to be prosecuting my client today in court. You will conclude for yourself. Because everybody has been reporting charges dropped or charges withdrawn and left it at that. Now I read into the record a letter that was sent to my office. To be fair to the NPA, I was notified shortly before the public announcement, because other than that, I would have continued to prepare for trial when in actual fact it was not going to happen. And I will give you members a copy of the letter that I'm reading from, so that you can see that I did not inscribe certain innuendos in it. Zola Majavu, attorneys, 170 Columbine Avenue, Mondio. Dear Mr. Majavu, date of the letter, 18 August 2015. State versus Nomgcobo Jiba. 1. I refer to the above-mentioned criminal matter involving your client, Advocate Jiba. 2. Pursuant to a request by the prosecution team to the National Director for the appointment of outside counsel to give an opinion as to the fact whether there is a prima facie case or not, writer hereof as regional head was requested by the National Director to provide an opinion and decision. 3. I have duly considered the evidence as contained in the case docket number Silverton, case 622/10/2014. The NPA policy directives and the applicable legislation. 4. Emphasis added. I have come to the conclusion that there are no reasonable prospects of a successful prosecution. You've heard this before. 5, which has not been said anywhere by anyone in the media. I decline to prosecute Advocate Nomgcobo Jiba on all 3 charges preferred against her. 6, the criminal charges will be formally withdrawn in court on 19 August 2015, duly signed by Advocate Marshall Mukhatle, Regional Head, SSCU. You can take that as a courtesy copy. I've got enough copies for everybody. I'm not going to comment on that. You will draw your own conclusions. What I will say, though, is that that decision was not as a result of any favors done. It was as a result of the engagement that those who took the decision had with the entire prosecution team, and they came to that decision. If they had not come to that decision, we would still be in court as we speak, defending ourselves. If for whatever reason the matter were to resuscitate, either in a form of a private prosecution, we will still maintain our stance that there is no case against her, and we'll go and have our day in court. I have the docket. And I can assure you that I have read that docket, and based on that docket, there is absolutely no case against her. But we have to respect the rights of those who feel aggrieved by the decision to decline to prosecute. Private prosecutions are made possible and are allowed for in terms of our law. And if that happens, we'll adopt the same stance. We'll look at what docket they have. If it's the same docket, we'll say, give us a date tomorrow and let the show begin. So we are not scared of this matter. It is just that it would have been a waste of resources for everybody concerned. But if the state or anybody else believes that there is indeed a case for her to answer, we had availed ourselves to do so. Let me now then quickly conclude by going to the narrative, because this too was made a meal of in the media. It was reported that because she's a diva, she even refused to accept the summons. You remember how the story broke. The summons that was aimed at securing her attendance in court. Normally, a person gets arrested, and I'm going to make it very elementary. If you commit an offense in the presence of a peace officer, they can arrest you there and then. Take you to the police station, you then have 48 hours within which to be charged, and then you make your court appearance. Alternatively, your attendance in court can be secured by way of a summons. What typically happens is that the investigating officer of that particular case will approach the clerk of court with the docket and say, based on the information I have at my disposal, which is borne out by the docket, kindly issue a summons. A summons being a document that basically says to the person who is sought to be brought before the court, appear in court on such and such a date to answer to the following charges. Now, the person who issues that warrant must have a basis. Can you imagine, Nicholas, if anybody can go to the clerk of court and say, issue a summons against Nicholas? There has to be basic minimum requirements that must be met. Namely, there must be a reasonable case against this person, supported by some information in the docket. That is what usually happens. And once the clerk of court is satisfied that there is a reasonable case against this particular person, based on what they are told by the investigating officer, armed with the docket, they would then issue that summons. That is how the summons that we are talking about was then obtained against Advocate Jiba. Now let me tell you this, because nobody will tell you. The person that obtained that summons was not the investigating officer at the time, one. Two, the docket was nowhere next to that court. The docket was with the investigating officer in Cape Town. Three, when my client was asked to sign for that summons, that invalid summons, she took issue with it. And on the face of the document, it will tell you who the investigating officer is. She contacts the investigating officer to find out what is going on here. The investigator says, I'm in Cape Town. I don't know anything about that summons. She then decided, rightly or wrongly, to say, I am not going to acknowledge receipt of that summons. And I am going to show it to you once we are done here. But that summons was then signed for by her predecessor. It's not a secret. It's a matter of record. It was then on that basis that she got to know that she had to appear in court. The first date of the court hearing being the 21st of April in court 19. They even got the court number wrong, because there is no court 19 in the Commercial Crimes Court, where we were just now. This is the document I am referring to. I'll make it available. Look at the information. You will draw your own conclusions. That summons was accompanied by a provisional charge sheet, which basically sets out the charges that my client was facing. Do you want to know who signed for it? Mxolisi Nxasana, not because I say so. There's a return of service. Now, When I first consulted with my client, her instructions were bring an urgent court application to set aside that invalid summons. Having established from the IO that the docket was nowhere next to the clerk of court on the day when that summons was obtained. Nobody says anything about it, but when someone stands up to assert their right, they are called a diva. We took issue with that in court on the 21st to say we want it placed on record who the exact investigating officer is, because we knew where we were going with that, because we had spoken to the correct investigating officer who disavowed any knowledge about how that summons was procured. And there'll be consequences in a separate matter for those concerned. I'm just sharing with you because I'm trying to contextualize the circumstances in which she refused to accept that document. Because much was said in the media about, it's a pity Bateman went out, because he too went to town about it. She refuses, she thinks she's above the law. And now for the first time I'm saying, here's a document. It's in the public domain, I'm giving it to you. Look at it. I then said to her, let us not challenge that summons. Let us accept that it has now come to our attention and have our day in court to deal with the substantive issues raised in the charge sheet. She was unhappy with what I said because she felt I'm hard done by. I'm painted as this something terrible in the media when my rights are violated. I then said to her, actually, if you bring a high court application, you are going to give momentum to those allegations. Let's rather go to court and stand accused on the charges as per the charge sheet and deal with it there and then. And she accepted the advice. That is why the matter was then enrolled for trial. We did not take technical points. We said, if you say we're guilty of 3 charges, bring it on. On that very first day in court, we said to the court, we are ready to go to trial. Give us a date. What did the state say? No, we still require an opportunity to finalize our investigation. There are 2 or so outstanding statements that we must still obtain. I challenge you to go to that record of the court on the 21st of April, play back the tape or get a transcript. You will see that the prosecutor did say he still requires an opportunity to get 1 or 2 outstanding statements. We then said, take as much time as you need to get those statements, but from where we are standing, we are trial ready. The matter was then postponed to another date. On that occasion, we were given the contents of the docket. Note this, we were given 3 CDs, not the docket in the traditional form. We had to go make our own copies, which we did, and they came to 1,475 pages. And based on that, we then said to the court, we are all now ready. Myself as the defense, the prosecutor, on behalf of the state, we then agreed that the matter should be set down for trial for today. Because both of us knew the magnitude of the docket, we asked the court to give us a few days so that we don't start, stop. That is why this matter was enrolled for at least initially 4 days. Today, tomorrow, and 2 other days in September. And we proceeded on that understanding that we are going to trial. For the record, we did not even make representations to the state to say they must withdraw charges. We took the view that we have been called upon to answer to 3 charges, bring it on. It is the state that decided on its own to refuse to prosecute, not to withdraw charges. Charges were withdrawn because the matter was enrolled before the court. If the matter was not before the court, we would not have attended court ourselves today because the matter would simply have been withdrawn. But because the matter was postponed for trial, not even the magistrate knew, other than if he had read the news, that the case was not proceeding. Everybody went to court today knowing that the trial is proceeding. And that is basically where the story is. And I am saying to you, if the state were to have a change of heart and decide to prosecute her tomorrow, we will be ready again tomorrow and deal with it. So the vindication comes from the fact that the state itself says they have looked at the matter, they do not believe that there are reasonable prospects of success. That's what they say. And that is not what is being put in the public domain. But you can read the letters on your own and draw your own conclusions. That is how the matter then came before where we are today. In conclusion, I give you my word of honor, colleagues, that as soon as the High Court application is finalized, or there is any significant milestone in that regard, I will come back here again and share with you the developments that would have transpired on that matter. What I am not prepared to do at this stage is to act uncollegially and put stuff in the public domain that I am yet to share with my opponents. Once that has happened, I will gladly give you the case number and say, go to the court, uplift the contents of the court file, because we live in a constitutional democracy. That then concludes my explanation of where we are. I'm more than happy, I'll be guided by you in terms of your time, to take questions. Nicholas? Any other takers? My brother, again, sorry. I've got 2 questions that we can start off with. Nicholas, go ahead.
Now, the former NPA head in Nkosana said in a press conference earlier this year that your client enjoyed political protection. And would your client care to address that allegation? And will she be taking action against the former NPA in this regard? If not, why not? And then secondly, Advocate Jiba, you began this press conference by saying how important family is to you and saying how your family was deeply affected by these allegations. How can we be expected to believe your statement that the expungement, your husband's criminal record being expunged does not affect you if you made the point that family is so important to you and at the end of the day, he's the father of your children?
I'm going to respond. I'm not going to allow my client to deal with that. Let me deal with the Mr. Ngasana issue first. My client's position with regard to that is dealt with in her answering papers. But secondly, to be fair to Mr. Ngasana, we do not want to participate in a public mudslinging of who enjoys what, because the same could easily be said about him. There are those who are grieved by the fact that he received a payout for whatever reasons. But my client's view is that if she has an extra grant with Mr. Ngasana, he will follow proper channels and deal with it accordingly. At the end of the day, she too is a member of the legal profession, just as Mr. Ngasana is. And there are protocols in how we deal with each other in the legal profession. With regard to how important family is, I think with respect, we all know that we feel very strongly about our families. What has been done to her husband has got absolutely nothing to do with her, unless if the suggestion is that she played a part in how that decision was arrived. And I therefore feel that it's an unfair question, and I will advise her not to even bother to respond to it. But if she so chooses, she's here. I'm not protecting her. Ma'am, do you want to deal with that issue? Okay.
Mr. Machapa, I listened to you carefully. I listened to your submission that Mr. Ngasana signed. You have the right to answer or not to answer. I'm getting the impression that in due course you'll be making an application that Mr. Ngasana was behind the GCP application. What is your comment?
I am known to shoot straight from the hip. We are not making that allegation. We are not even making that assertion. All we know on record is that the GCB brought the application, supposedly on its own, and we are prepared to accept it as such. There is nothing wrong in the GCB bringing an application. We are, however, raising a number of procedural issues about how that came to light. And I do not want to be unfair to Mr. Ngasana by making unsubstantiated assertions. It is none of our case that it is Mr. Ngasana who did that. We assume, and we have learned from the court papers itself, that the GCB is bringing this application on its own accord. having had regard to the various judgments. And in the course of the documents that we have exchanged, there is also correspondence from the NPA itself that we are dealing with in our papers. The identity and the nature of those documents will become public knowledge, because once we file those affidavits in court, you can access them without needing my client's permission or consent. Once again, my client is not saying anything about Mr. Nxasana other than saying, with regard to the summons, it's a fact. He is the one who signed for it, and he said it so himself. You will find that on page 2 of the J175. J175 is a summons. Now, the person that went to deliver it must get the recipient to either sign for it, to say, I have received it, or if not, anyone who is in the same employ and is above the age of 16 years old, our law so says, can sign for it. And in this instance, it was signed for by Mxolisi Sandile Oliver Nxasana, and he put his ID number, cell phone number at 1255 in Silverton. I say this because this is the document that we were given by the state itself as part of the summons. And I'm not suggesting that there's anything wrong in him having signed for it. Could have been anyone above the age of 16. Could have been the cleaner, the tea lady, or anyone in that building. As long as you are above the age of 16, you may receive documentation. So we are not suggesting that because he signed for it, therefore there's a plot. That is not what we are saying. I was simply responding in the context that it was said that Advocate Jiba did not accept service, which is true. She did not, because she took the view that she should not accept service of an invalid document. Whether she's right or wrong is a matter for another day. So I'm stressing this. She is not making a point that the fact that Mr. Nxasana signed for the summons, there is something untoward. That is not what we are saying. It could have been signed for by anyone. What she is saying is that she definitely didn't sign for it. I'll take you and I'll take the lady behind me. I see she's... I don't know if you wanted to raise a hand. Sorry. If I am mistaken, accept my apology.
Advocate Jiba, on that day when
no one knew where you were, and when the summons was supposed to be signed on to you, were you in the office of General Vehicle or not at that stage?
Yeah, sure.
I was not AWOL, for starters.
Please help us with that.
I can never be AWOL. I'm a very senior member of that institution. It would be irresponsible of me to be AWOL. I went to the office on that very same day. I went because I had an early meeting. And I was not feeling okay at all. My PA can be a witness to the fact that I went running to the bathroom. I can't say what I went to do in the bathroom. Then I went to the doctor. You can safely go and see my doctor. He was very angry about what was happening to me because he knew very well that he detained me in his rooms. And I don't understand, how can you be AWOL just in a day? You can't be AWOL in a day, naturally. I hope that answers your question. I can never be AWOL. And I can't run away from a summons. You know, even hardened criminals, they don't run away from summons. They run away from a warrant of arrest. Because then you know you are going to be detained in some cells. But from a summons, I've issued those things many a times. It just appear before court on this day. It doesn't take you to court even on that very same day. It just notifies you that go to court on this day. So it's stupid even to suggest that I was running away from a summons. Very, very stupid. Thank you.
So did you visit General Pieko or did you not?
No, I did not visit General Pieko. The only person that I called, indeed, as my legal representative saying, I only called General Taiwa because he has promised that once he has finalized the investigations, he'll come to me, he'll give me an opportunity. So naturally, I was not understanding what is now happening, why there are summons now and all of those things, you know. And in any event, let me expand on this. In the National Prosecuting Authority, we've got a policy. If any charges are going to be preferred to a person of my position, to a director, that is the head in the provinces, to a brigadier, to a general, and all of that, investigations must be finalized. And that docket must be submitted to a director of public prosecutions to make a decision. That's the procedure. I have done that with regard to my own colleagues. You would know that at some point in time, my colleagues too, who are deputy national directors, there were investigations that were going on about them. And this never happened to them. That's why I just have this feeling that I have really been treated unfairly by you, members of the media, and by my institution itself.
I think when you look at the document, just to make the point, the document was actually served on the 24th of March, and it was saying she must appear in court on the 21st of April. So even if she had received the document personally on that day, it was not saying go to court now or you are under arrest. It was simply saying you have a month within which to voluntarily present yourself before a court. So there would really be no purpose served in running away from a summons as it was put. But once again, don't believe me, look at it or go to the clerk of court and see if the copy that I've given you or shown you is the same as what they have in the official records. I'm more than happy to take questions, colleagues, unless if your time does not permit you. At some point, I'm going to have to release my client who has some prosecutorial decisions to make.
It's a technical question,
Sure.
sir. Summons are not voluntary. You don't have a choice. You have to go. And just because I was not aware of a summons being issued doesn't make it invalid. Surely.
Look, ma'am,
What made the summons invalid?
I do not want to debate the legalities thereof with you, because I can refer you to a section in the Criminal Procedure Act that tells you how summonses of this nature are obtained. I tried to keep it less technical. All I am saying, for the summons to be issued, at the very least, the investigating officer must go to the clerk of court with a docket and give some basic facts to satisfy the clerk of court that a summons can and must be issued. It is not there for the ask, it is not there for the take. If you want us to debate those technicalities with you, once the formal thing is concluded, I will be able to take you through those issues. It may well be that we are right or we are wrong, but the fact of the matter is we were challenging this, the summons. And secondly, you cannot say a summons is voluntary. A summons takes effect when it gets to the attention of the person for whom it is intended. Once again, it's not me saying, look at the Criminal Procedure Act, maybe I'm lying. But the point of the matter here is that she was not running away from this summons as it was reported in the media, because a summons by its nature is a form of securing your attendance before a court. You can secure, your attendance can be secured to appear before a court by either a summons or by an arrest being effected on you. And in many matters, I've done many commercial matters before, the police would normally phone you up and say, ma'am, please present yourself at our offices because we have a summons against you, to avoid them effecting an arrest. And in most of the commercial matters, it happens that way. There is nothing wrong with that. The point being made here is that as far as this particular summons is concerned, and let's agree to disagree, my client's view was that this summons was not obtained properly, and therefore it is invalid. And if it is invalid, it has no force and effect. Had we challenged this and succeeded, and I'm just giving a hypothetical case, and succeeded, there would be no case to talk about. They would have had to redo it and reissue it properly, which I suspect would have happened. That is why my advice was to client, let's not even quibble about the technicalities. Let's go to court to answer to the charges that have been attached to the invalid summons and deal with it. So we waived, if you like, our right to take issue with how the summons was obtained. That is why we were supposed to stand trial today. We did not take that point anymore, but we did place it on record. And if you are really interested in following that aspect up, go find out who was the investigating officer who had the summons issued and find out what happened to him or where he is now in relation to this very matter. All I'm saying, for the purpose of this interview, a summons was served on my client, accepted by her colleague. We accepted it. We went to court on that basis. Any last takers? Zachary. Any last takers? Okay, colleagues, this then concludes our press conference. Yeah, you can.
Holy, as I said, I'm not sure if you have my I'm going to speak to you.
Just want to call me Titi.
Yes. So they'll speak to you at training. Can I just get a number?
Yeah, 082, he's got it. 082 411 5348. 082 411 5348.
Okay, 20 past 4.
It's fine. That's okay. Yeah. Yeah, that's. No, I just wanted them to see it. Oh, thank you. Thank you.
We'll stay in touch.